Hey there, listeners. It's your host, Casey Fatchett, and we have a very special episode of the Nerdy Photographer podcast for you. The Supreme Court of the United States just handed down a decision in an intellectual property copyright infringement case between the Andy Warhol Foundation and photographer Lynn Goldsmith. And I'm talking to law professor Jessica Silbey about the implications of this decision and how it will affect not only visual artists, but artists in general. So be sure to stay tuned after the break for that discussion. Do you have your own website? Are you tired of dealing with slow loading pages and poor support from your current web hosting company? Consider switching to SiteGround, the top rated web hosting company that provides 24/7 support and super fast hosting speeds. SiteGround's platform is built on the premium Google Cloud infrastructure, ensuring top reliability, security, and speed for your website. Their fast network and storage provide optimal site speed and a high level of redundancy, so you can trust that your website will be up and running smoothly at all times. With SiteGround's ultra-fast server setup, your pages will load 30% faster on average, giving your visitors a better user experience and improving your website's SEO. And with hosting starting from just $199 per month, it's affordable for any budget. Plus, if you're not completely satisfied, SiteGround offers a 30-day money-back guarantee. Don't suffer with a terrible web hosting company any longer. Make the switch to SiteGround and experience top-level support, super fast hosting, and a reliable, secure platform for your website. I spent years with a web hosting company that was absolutely terrible. My site was constantly getting hacked and support was nearly impossible to get a hold of. Since switching to SiteGround, all of those problems are in the past. Just visit nerdyphotographer.com/recommends/SiteGround or click the link in the episode notes to get started and begin enjoying faster, more reliable web hosting today. Hello, and welcome to the Nerdy Photographer podcast. I'm your host, Casey Fatchett, and with me today is Professor Jessica Silbey from Boston University, BU. Jessica is a professor of law, and we're going to talk about today the recent Supreme Court decision ruling against the Andy Warhol estate versus Lynn Goldsmith regarding a photo of Prince. Jessica, I mean, maybe you can better explain this particular case, which I originally remember reading about your article in Salon when it first kind of made the courts.
Yeah. So it's actually against the Andy Warhol Foundation, which is the organization that holds the copyrights to Warhol's work. So Lynn Goldsmith is a photographer who in 1981 was hired by a magazine to make a photo of Prince, the musician. And it was going to be in a magazine about him. And it was a black and white photo. And it never got used, actually. Some of the concert photos she took got used in the magazine, and it was in her archive. And then in 1984, Vanity Fair paid her agent a $400 fee to use that black and white photo as what's called an artist's referent for a cover of the magazine that they were going to give to an artist who turned out to be Warhol to make a new cover of the magazine. And so Goldsmith got $400 for this single use as an artist referent. And the cover of the magazine in 1984 was what's called Purple Prince, the big purple faced.
Yes.
Yeah. And then after Prince died, Vanity Fair came back and said, have any more any more prints of Prince?
Yeah.
To Andy Warhol Foundation. And they actually had 16 because when Warhol was making all of his art to try to figure out what to put on Vanity Fair, like many artists, he made a lot of things and then gave them the purple one. But there are actually 16 different kinds of renditions he made. And Vanity Fair, then Condé Nast, took what's now called the Orange Prince and put that on the cover in celebration of Prince's oeuvre and in memorial. And then Goldsmith saw it and like, I didn't approve that one.
Right.
and she sued. And she sued claiming that was an infringement. Well, actually, she didn't actually sue. I take that back. She sent a letter to the Andy Warhol estate. and said, you violated our rights. And Andy Warhol sued her as a declaratory judgment saying we're not infringers.
Yeah, it's kind of it's interesting in just the legal aspect of like what was originally approved, the usage for what it was originally approved for, and then just like, okay, we're going to continue making money off of this.
Yeah, it's hard to know. I mean, so I have a lawyer hat, like when I'm advising clients, and I have a teacher hat when I'm teaching my students the complexity of copyright law. And I think if you look at the license that Lynn Goldsmith gave Vanity Fair, it was a single use for a cover, right? That's what it was. And Warhol didn't get a license, though. Right. So it was like not a buttoned up legal transaction in any way, shape, or form, and that would have made me comfortable as a lawyer a long time ago.
I think that this is really important for visual artists and photographers to understand. And I think it's something that we tend not to think about because we're creatives. We don't like to think about the business side of things, but having sort of buttoned up agreements and licenses for what things can be used for, but also being able to protect your work and what happens to it afterwards, which has become in the digital age such a, I don't know, sometimes it feels like an overwhelming task to like keep control of your work. And I still see things, and it boggles my mind because there's a younger generation out there. I mean, I don't know. I always refer to it as like millennials and Gen Z sometimes have a questionable legally thought on if something is on the internet, then I have the right to use it.
Then it's free. Right. If it's on it, Yeah, so there's definitely a shift in norms and expectations about access and the relation of access to ownership and use that the law has not caught up to at all. So, my students do not like that I make them buy books, for example. They want everything online or downloadable or, I hear that it is very hard to figure out how to manage one's assets in a digital space. I think one of the things I do when I try to work with artists of all kinds, and I do that all the time, is to ask very particular questions about what you're trying to accomplish. I think that, unfortunately, it's not clear to me that copyright law serves most artists very well. And so I'm very in favor of figuring out ways to get artists what they need, maybe not using copyright as often as I think people want to rely on.
Yeah, I think that that is sort of like, at least in my industry, I think that people sort of like fall back on that. It's sort of like, well, it's just going to be covered by copyright law. And now we've got, there's all this questionable gray ethical areas.
People contract around copyright. They click terms of service that like waive everything. Like there's just all these different ways that you don't have control. And so trying to figure out what you're trying to accomplish with your work, I think can be much more helpful for visual artists. And I just think Lynn Goldsmith, I mean, she was contracting in a time in 1981 when we didn't have an internet like that, right? And there was actually an archive, and what her agent did was give Vanity Fair an actual print or a negative, right? I mean, it was a completely different situation. But I think we can also, I mean, I'm sympathetic to the other artist here, which is Warhol, in that he, as an artist himself, he thought he was given the opportunity to make art with this thing. I mean, I think that's what he was told he was doing. And so part of the question is like, didn't he make art too? Like, what is the right outcome in this situation, given we have two artists who were trying to make a living at what they're doing? I think that's actually the most important question.
Yeah, and I think that maybe where we get into where it does again get into a gray area is in that second usage, like where we're like, or it's just like taking all the things, like, for example, if I am hired by a company and they want to buy out like X number of photos and have those as they're buying the copyright for those photos, and they can take those, but what about all the other pictures?
Yeah, right.
And
they want all the outtakes,
right? But that's the thing for me is I don't deliver high resolution of any of that stuff. But then you'll see people like, oh, well, we had this in our archive, so we assumed that even though it's low resolution, that we could use it. Like, oh, no, we can't. And that's
one of the things that also I'm hoping this will work itself out as the years go by. But those who are managing archives right now in places like Condé Nast or the New York Times or whatever are not the people who are thinking hard about copyright law or permissions. And just like if it's on the internet, you can scrape it and put it in a PowerPoint. They think if it's an archive, we can just use it
for
like a whole other purpose.
Right. They think that they just have
photo in a war zone. Now we're going to use it like as an ad. Like, no, no. But so these are just conflicting norms of different forms of different kinds of employees in massive organizations. And I do actually worry very much that there is not a norm management of these assets from top down. And I think that more and more we should be talking about that.
Yeah, how we manage like the library of media. Yeah. And there really isn't a discussion about that. I mean, I've had like some of my photos have been used in various publications and magazines and things. And I'm like, kind of part of me starts to think like, wait a second, they have like a print ready, like large format, version of my photo. Like what has happened to that? And I actually had years ago, somebody took a photo of a couple that I had taken for the couple in Brooklyn, near like the Brooklyn Bridge in the background, and someone scraped it off the internet and decided to use it for a dating site.
Oh,
like it was the hero image on the site, and I found it. And I was like, "What are you doing?"
It's so derogatory. Yeah,
yeah,
it's not. So on the one hand, it could just be laziness and recklessness. On the one hand. On the other hand, and disregard, just total disregard. On the other hand, I think there are just basic misassumptions about things. And, what some of the things, I mean, again, the Lynn Goldsmith situation, that wasn't, it was 1981. It was a completely different situation than, when Prince died in 2016, that's a long time from 1981 to 2016. And these Andy Warhol artwork are in museums. They're all over the world and in private collections. And then the Warhol Foundation licenses copies, in posters and stuff like that. And, that feels like a very different situation than what you're talking about, which is, I think a sort of a question of how do we elevate the understanding of respect for people's photographs, of people,
made
by people, right? Like that's just, and we have lots of conversations right now about non-consensual photography, privacy violations. Like we're talking about that, with our kids and our students and in Congress. Like, what do we do when we send photo? We could also be talking about how it's a dignity violation when people's works are misused this way. But that to me is very different.
It's a different conversation. Just anecdotally, but like I think what you're dealing with here is that both of them, both the Andy Warhol Foundation and Lynn Goldsmith, were both commercially licensing this image at the same time.
I don't personally think they're substitutes for one another. Right. And so I struggle with the question. And I think it's an important and hard question about where the line between unlawful copying and new creative uses of underlying work is. And so I think that, unfortunately, this court did not help with that line. That's the line we wanted help with.
Right.
And this court, I have lots of things to say about this court. I also teach constitutional law, so
there's a lot to go into.
But, this decision that they issued yesterday did not clarify things for us, and it made things even more complicated, and that's just not good for anybody.
Yeah,
that line is an important line to talk about.
Right. I think that they kind of like took away like some of the clarity in some ways. Like it's like I can't even remember who it was. I can't remember his name.
He's Sotomayor who decided the case.
No. I'm thinking back to it. It's sort of like the ruling of like, I know pornography when I see it.
Oh,
it's
yeah. That's the First Amendment.
Yes.
That's right. Yeah, the First Amendment. Right.
But that was, I think that was famously brought up in like, I can't remember his name. The photographer used to date Patti Smith.
It was a photography case? Oh, really? I didn't know that.
And it's like he was getting some NEA money, and there was discussion as to whether or not it was pornographic, and there was discussion saying like, I know pornography when I see it. So that's kind of like become like I know transformative.
Yeah.
When I see it.
Yeah.
So there's no like, hey, this is what it's going to be.
Yeah.
Like from moving forward, it's going to become more subjective as far as like decision making, as far as like whether or not you have transformed the work.
Yeah. Yeah. No, right. I mean, so the rule cannot be that a court knows it when they see it, right. That a jury knows it when they see it. Like that just impinges all sorts of free speech. And so, I mean, one of the things that I talk about with my students a lot is thinking about, who are the stakeholders in this decision? Like whose interests are involved? And so this is a case between a very prominent photographer and a really famous artist.
Right.
Like this is not a David and Goliath situation. This is a Goliath and Goliath situation within a context of successful artists, right? So I worry a lot that a ruling that is so unclear and prioritizes, I think, commercialism over everything else, over art, actually. Right. Is going to hurt everyday artists, and I want more people to worry actually about the freedom of expression that copyright law is supposed to promote by giving people leeway to actually make work. Yeah,
I was going to ask you, like, what do you feel like the major implications of this decision are?
Well, I mean, that's always a hard question because what happens with Supreme Court decisions is that lower courts then start quoting pieces of them as they apply them, and parts of it gets reified at the lower level, and we'll start seeing what parts of the opinion sort of take hold. Right. And I think there are two possible parts of this opinion that could be anchors going forward.
It's trickle down precedent.
Yeah, neither of which are. I mean, on the one hand, it could be a very narrow decision, which says if there was a license for a particular use, and the entity who licensed went beyond the scope of the use, that's not a fair use. That's an infringement. Like right. And that's a very narrow, and it's a very unlikely situation because many people don't engage in this kind of licensing in the first place, and it doesn't help us with the hard line drawing. I don't really like that ruling, to be honest, because it doesn't ask the question about whether what Warhol did with the photo is a copy, is an unlawful derivative work, or whether it is, in fact, a fair use. Like, it just doesn't help us with that question, which I think is one of the most important questions. So that's one way of thinking about this case, which means that we might see a lot more licensing behavior, like paying attention to licenses. And I don't like that ruling because I actually think that most artists do not have power in licensing negotiations. And so if the scope of the license and the nature of the license is going to dictate what can happen in the future, the people who do not have power in that negotiation are going to lose.
Right. The artists who generally don't understand licensing to begin with are going to get taken advantage of.
Right. So although this may look like a win for Lynn Goldsmith, and it might be, although we have no idea what she's going to get for the win, like whether she's just going to get a licensing fee, which is like such a big deal after all this. But it's not really a win if you can't negotiate those licenses properly. So that's one thing. I think that there's another way that this case could be affected is that there's this rule in copyright law, which is the more you transform aesthetically the second work, the more the Warhol looks really different from the Goldsmith, the more likely it's going to be a fair use and not an infringing use. Okay. So that's typically been the kind of thing that we ask, at least when we balance the four factors in fair use. This decision could be interpreted to say that that's really not what's the most important thing, and that judges really shouldn't be paying attention to these aesthetics. That's not that, yes, that matters, but what really matters is whether the two uses to which the works have been put are the same. Are they both songs? Are they both magazine covers? Are they both, I don't know, software code?
Yeah.
Like, are they all if they're the same thing, it doesn't matter how different the thing is. They're both being used
for the same purpose. Yeah, which brings up a whole other wave of sampling. Stuff. Like, how are you going to have any sort of samples in music at all?
Right. So this is where, I have a lot of thoughts on when the Supreme Court dips its toe in the well of intellectual property without really understanding what's going on. I mean, it doesn't often take IP cases, but it's been taking IP cases at a much faster clip the past 15 years. And yet these are judges who are generalists. So they see more frequently, they see criminal cases or they see constitutional law cases. And so they don't have a lot of experience with IP. And, it just shows sometimes in these decisions.
It doesn't feel like as weighty or as thought out. Or like as far as like, we have an ultra long thought out decision on.
Yeah. So if you read Sotomayor's opinion, which I don't think your listeners necessarily going to do, but I'll encourage people to read Justice Kagan's dissent for a reason I'll say in a minute. But Sotomayor's decision starts unraveling. It's like really unclear, even to someone like me who studies Supreme Court opinions. It is not a well thought out opinion. And in the footnotes between her majority opinion and Justice Kagan's dissent, they are fighting. It is like a war of footnotes. It's super interesting, actually, because they're usually on the same side of things. They are not seeing eye to eye on this, and it's hard to figure out what's going on in the background. So there's sort of an interesting tension. And it creates confusion in the way that the opinion is written and reasoned. Justice Kagan's dissent is full of art. So people who are listening, who are interested in visual art, she has lots of different ways of explaining appropriation and borrowing and homage and sort of reasons in literature and music and in art to say why clarity in this situation is really important, because we've had a history of borrowing and sampling as long as we've been creative
people. People just like painting over other paintings and
or being be honoring other kinds of artists by in their style of and so if this opinion,
homage
right, that's the whole idea, right? So if this opinion chills that kind of behavior because people are afraid of being sued. And of course, the people who are going to be afraid of being sued are the people who are struggling to do the work, not necessarily the people like, come get me. Like, I'm Google, come get me. You can sue me. Right. So it's not okay.
This immediately made me think of another Prince, Richard Prince.
Oh, right.
The Instagram.
Right.
Yeah. I saw those pieces at an art fair here in New York. I was photographing and I was just like, how can you call that transformative? All you did was change the caption, but you used somebody else's photo without their permission. Yeah. And you're selling it for $100,000.
Just by changing a caption.
Right. And you're not even thinking about like using the likeness of another person.
I have to say that's the thing that bothers me the most about those cases. I really feel for the subjects of those photos who have given their permission once and have not necessarily given their permission 1,000 times to be reappropriated. There are some artists, though, who have gone and talked back to Prince by taking photos of those photos and selling them on and like blowing them up and selling them online for like $40 and basically saying F you.
Like, I'm going to destroy your market.
You in the market, So Prince can afford to be sued.
Yeah.
Right.
Because he's making hundreds of thousands of dollars.
Yeah. But I mean, this is a critique of the art market more than it is about copyright.
Yeah.
I just want to say. Right?
Yes. Yeah. The fact that like anybody's allowing that to happen as an art dealer.
Or that we're valuing it.
or the people who are buying it. Yeah.
Yeah, I mean, it's a form of arbitrage and a form of wealth aggregation. People who collect art who are betting on certain artists. We could be supporting other artists with our money.
Yes, we could. I think that's overall is probably the sentiment that allowing people to create, and find their way. And I mean, there's a phrase that I think I've used before on the show. You can imitate, emulate, or innovate, and sometimes imitation is your way of getting to innovation. And like finding the way that people did it. And me personally, I don't try to exactly copy anybody else, but I do look to other artists in all sorts of visual media as inspiration for what I do.
We can't help it. It's just how we learn.
Yeah. And so and then you will have things that you unknowingly at times will recreate something somebody else did, because you're like, oh, I didn't even know, I had looked at somebody else's an entirely different work, but then it gave me this idea and we came to the same place, but people are like, oh, that's derivative of this.
Yeah. I mean, copyright has this crazy doctrine called subconscious copying or unconscious copying. So even if you copy, but you don't realize you're doing it, you're still an infringer. I really think that should be excised from the law. That's just a form of mind control. That's a real problem. Right. I mean, I did a series of interview. I wrote a book almost a decade ago called The Eureka Myth, which interviews a bunch of artists and innovators and stuff. And there's a chapter in that book that confirms sort of exactly what you just said, is we have to copy to become who we are, but we eventually try to become who we are independent of the copy. There is a trajectory, but constraining people to do that kind of learning from the masters or building scaffolds from earlier genres or even collaborating. It's just the idea that copyright law could get in the way. It's just something that makes people nuts.
Yeah. I mean, it kind of makes us I wonder if we're going to re-examine other things, especially Warhol. A lot of his works, the copies of other people's work.
Candle soup cans.
Yeah. Or the Monroe. All those things that are just an iteration of something else.
Yeah. I mean, his contribution to art was the commentary on consumerism. Right. I mean, I think there are a lot of photographers. I'm a huge photography fan, and I've written a lot about photography and digital photography. And a lot of the photographers who I think make some of the most beautiful photos are making photos of other people in the world. They're copying the world as it exists out there, but they're bringing their expertise of, lighting and angle and patience and, physicality to the shot. But they're literally copying other buildings and people's clothing. And, so, the idea that art is not somehow just building off other people's contributions to the world is just false.
Yeah, I think it's kind of funny when you think about it that way. Warhol's commentary on commercialism and consumerism, and that's kind of what this decision was completely based on.
Profoundly ironic. That's a great point. That's a great point. Yes. In fact, I think the dissent, Kagan says something about, it made me laugh actually, something about the majority's consumer uber alles. It was really funny. It was commercialism all the way down. And part of what's so depressing and tragic about that at some level is most artists I know, although everyone wants to make a living and they want to be able to sell their work and they want people to own the work and appreciate the work, they're not doing it for the money.
Right.
Lord knows they could be making a better living doing something else.
Yeah. And I think that there's this feeling, I think, among artists that I know in various mediums, not just photography, it's sort of like if I was making a living wage or a comfortable wage, I wouldn't care if I sold any of it. It's sort of I want people to see it.
Right.
I want people to see it. I don't care if you buy it from me or whatever, as long as I'm making enough to like live on.
I so feel that, and I love hearing that, because it for me, it just makes me think we have to figure out a way to keep artists working, and support artists. Copyright is most definitely not the way to do that, I don't think. But I don't think giving up copyright is going to work either. So I'm moving forward as I think about my work as a lawyer and a teacher, trying to figure out what the right reform efforts can be. But the goal has to be keeping artists doing their work, for sure.
Have we got a special offer for you? Do you enjoy listening to your entertainment? Why am I even asking, folks? You're doing it right now. You must. With Audible, you can enjoy all of your audio entertainment in one place. From bestsellers to celebrity memoirs, mysteries, thrillers, motivation, wellness, business, and much more. Audible has an incredible selection of audiobooks across every genre. But that's not all. Audible also offers exclusive Audible originals from top celebrities, renowned experts, and exciting new voices in audio. Plus thousands of podcasts from popular favorites to exclusive new series. And with the Audible app, it's easy to listen anytime, anywhere. Whether you're out photographing landscapes, editing pictures in your studio, or going on intergalactic adventures with the Nerdy Photo crew, you can listen to your favorite audiobooks and podcasts wherever you want. New members can try Audible free for 30 days. So what are you waiting for? Go to audibletrial.com/nerdyphoto and sign up for Audible today and discover your next favorite listen. That's audibletrial.com/nerdyphoto.
Hey. And now for my favorite part of the show. What's that say? Useless information. This is always death.
We're going to go with our useless information for this episode. Jessica, did you know that brushing your teeth is the only time that you clean your skeleton?
No, I didn't.
Something with our special, like eating bones. It's a weird, like somebody mentioned that to me and I was just like, yeah, there's no other time that you're like going through your other bones and giving them a scrub.
I hope not anyway. Right.
I hope not. Well, who knows, people out there. Jessica, thank you so much for being on and coming on. And it was a little short notice. You also have another book out called Against Progress, Intellectual Property and Fundamental Values in the Internet Age. I'll include a link to that in the episode notes. I don't know if there's anything else you want to pitch or where people can find you. If you want.
I'm at Boston University Law School. If the photographer is listening, I have a couple articles on digital photography and copyright. Might be interesting. The first chapter of Against Progress is a chapter all about the photographers I interviewed over the course of 3 years with 2 colleagues. And it's full of probably photographers that some of you might know, actually.
Entirely possible. Again, thank you for coming on. If there's anything else that comes up in the future, any rulings or anything you want to discuss, please let me know. You're always welcome to come back.
Well, there's a case coming about dog toys and trademark, if anyone's interested, but I don't know.
Dog toys?
Dog toys. Squeaky dog toys making fun of Jack Daniels, a dog toy called Bad Spaniels.
Yes. I've seen the toys. I am a dog owner and dog person.
Yeah.
So I've seen them before. It's also
Supreme Court's going to start talking about dog toys and trademark parody.
Parody.
It gets better.
That's a whole other parody is a whole other world.
Yeah.
Welcome back, everybody, and many thanks to Professor Jessica Silbey for being on the show. Please go into the episode notes and check out her book. The link is in there. And also, while you're clicking on things, you'll find links to subscribe to this podcast. You subscribe wherever you're listening, or, maybe leave a review for the podcast on, say, Apple Podcasts or wherever you can leave a review. I would greatly appreciate it. That helps us reach new listeners. Also, you can follow The Nerdy Photographer on the social medias at The Nerdy Photo. That's at The Nerdy Photo on Instagram, TikTok, and Twitter. While you're at it, if you have any thoughts on this episode or what you would like to hear covered in future episodes, go over to the website, nerdyphotographer.com, and go to our contact page. And there you can leave a voicemail with your thoughts on this topic or on what future topics you'd like to hear about. We would love to hear from you. And until next time, stay safe and stay nerdy.
Who's that coming back to town? You better start listening. Who's your heart been beating about? You better listen.